All right, I'm going to call to order the public hearing on Z0373-17-CP and Z0374-17-Z. Today's November 1st. And first off, please join me in Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we begin, I already did that. Yep. You know, I've been reading the script trying to find where you asked me to do that. Now I see it. At this hearing, we will consider an application by Stafford Investment LLC affecting 5 acres of land located on the west side of Stafford Road at the northwest corner of the intersection of I-205 and Southwest Stafford Road. The application before us consists of 2 separate requests: a comprehensive plan designation amending the rural to rural commercial, and a corresponding zone change from rural residential farm forest zone RRFF5 to rural commercial RC. The hearing today will proceed as follows. We'll first hear a staff presentation from Senior Planner Martha Fritzie. The applicant will have up to 20 minutes to present. Next, I will open the hearing for public testimony, beginning with public officials. We'll have 5 minutes each. Then the representatives from recognized community planning organizations and agencies will have 3 minutes each. Finally, other people wishing to testify will have 3 minutes each. The board will then deliberate and either render a decision today or set aside a time to make a decision at a later date. Assisting us in the hearing today is our clerk, Kevin Moss, Senior Planner Martha Fritzie, Assistant County Counsel Nate Boderman. If you wish to testify, please complete one of the green cards and give it to Kevin. If you have a prepared written statement, please give a copy to Kevin and use your time to summarize what you have written. Everyone who wishes to speak will have an opportunity to do so. We'll now begin with the hearing with the legal statement by Nate Boderman, followed by staff report by Martha Fritzie.
Good morning, thank you. Now is the time for the public hearing, identified as ZO373-17-CP and ZO374-17Z. The hearing this morning is what we refer to as a quasi-judicial hearing, which means 2 important things for those wishing to participate. First, all the criteria that are relevant to the application and can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards those relevant approval criteria. So to the extent possible, please confine any testimony to those relevant approval criteria here. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker, here the Board of Commissioners, an opportunity to respond, precludes an opportunity to appeal that issue to the Oregon Land Use Board of Appeals. Failure of the applicant to raise constitutional or other issues relating to the proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue precludes an action for damages in circuit court. Once final, this decision is appealable to the Oregon Land Use Board of Appeals. At this time, I'll ask the Board of Commissioners to disclose any ex parte contacts, bias, or conflict of interest.
Who wants to start?
Sure. I have talked to Mr. Fallow on more than one occasion concerning land use issues, not specifically this, and I just want to make sure that folks are aware, and it will not influence any decision I make.
Ken?
Well, I don't recall if I have had any direct contact with the gentleman. However, on the chance that that may have occurred, again, I would say that these contacts would not have compromised my impartiality or objectivity in this or any other proceeding.
Commissioner?
Yeah, I don't have any conflicts to make in making a decision.
Okay. And I've known Mr. Fallow for many years. He's been a supporter of my campaign. I know the site. I visited on a number of occasions, including the let's see, there's,
Banker's Corner.
yeah, I'm trying to remember the, what do we call that when somebody complains about?
Oh, code complaint?
Yeah,
violation?
code, look at it for a code violation. I drove through it and looked at it, but, Rob has contributed to my campaign in the past, but I feel that, none of this will compromise my impartiality or objectivity in making a decision today.
Thank you, Commissioners. Hearing no intent to recuse, any of the Commissioners will proceed. If anyone wishes to challenge the impartiality of any of the Commissioners, please clearly indicate your intention to do so in any written or oral testimony that you may provide this morning. And that concludes the required legal statements that we must make at the beginning of each hearing such as this, so I'll turn it over to Martha Fritzie, our Senior Planner.
Okay, good morning. I'm Martha Fritzie, Senior Planner with the county's Planning and Zoning Division. We are here today to discuss a proposed comprehensive plan designation change from a rural designation to rural commercial, and a corresponding zone change from rural residential farm forest, 5-acre zone to a rural commercial zone. This proposal would enable the applicant to continue to run a landscape contracting and maintenance business from the property as that is a commercial business. And before we get started, in front of you there are 2 new exhibits that have arrived since you received your packet last week. Exhibit 15 is a short letter from Metro, and Exhibit 16 is an email that arrived this morning from a citizen. So getting started, the location of the site is on the northwest corner of the intersection of I-205 and Southwest Stafford Road. It contains 5 acres. It is zoned RRFF5, recall, which is a rural residential zone in the county's zoning ordinance. This is a recent aerial view of the site. It's currently developed with 1 single-family dwelling and a number of accessory structures. There is the single-family dwelling use. There is a nursery and accessory landscape supply uses on the property, which are allowed uses under the RRFF5 zone. There is apparently a landscape contracting and maintenance business on the property, which is currently subject to a violation being taken care of through our code enforcement folks. This property has some history. It has a history in the late 80s and early 90s of an electrical contractor being on the site under a home occupation permit. That's a permit that allows, as accessory to your dwelling, a small business. Those are allowed throughout the county anywhere where you have a residence. There was a conditional use permit application in 1997 for landscape rock sales and weathering of those rocks. It was denied. However, it should be noted that it was not denied because they weren't allowed to use it to do that particular use. It was denied because the hearings officer found that that's really just accessory to the landscape business that's there, and so therefore they were allowed to do it, and it didn't require the conditional use permit. In 06 and 07, the site was used for temporary storage by ODOT for equipment that they stored there while they were working on some I-205 improvements. That was done under what we call in our zoning ordinance a temporary use otherwise prohibited. Each of those was good for 1 year, and then the use needs to be removed from the property once it expires. And there's some history of violations on the property. Primarily, it appears the landscape contracting and maintenance business that is subject to the 2014 violation that's still going on right now. So for the comp plan and zone change, the relevant criteria are listed up here. There are a number of them, including criteria in our zoning and development ordinance that need to be met, county comprehensive plan goals and policies that need to be met. This is within Metro's urban service district boundary, even though it's not within the urban growth boundary. So there are potentially policies related to Metro that need to be met, and of course the statewide planning goals. And so rather than go through each one of these criteria, I'm really just going to jump to the main issues with this property. And I'm certainly available for questions if there are questions related to the criteria that I gloss over really quickly. They all are outlined in pretty good detail in the Planning Commission staff report that was included in your packet last week. So the first issue is the urban reserve. This property is located within an urban reserve. These reserves were adopted into the county's comprehensive plan originally in 2010. They are still part of our comprehensive plan. With that adoption, there were some policies adopted into our comprehensive plan, and those still exist today. The reserves were adopted by Metro in 2010 as well. There have been some subsequent changes and readoptions. However, in terms of the map, it has stayed the same in Clackamas County. The subsequent adoptions really related to some changes to the map and to the mapped reserves areas in Washington County, and also the recent readoption, as you're aware of the findings to deal with issues identified in the remand. And so in the application, the applicant asserted that because the areas, the urban and rural reserves have not been acknowledged yet, we do not need to apply the policies that relate to those. That's not the case. The court's decision to remand the reserves didn't change the designation. It didn't undesignate any areas. It's just simply delayed acknowledgement. And so I threw a map in there. You can see from this map that this, I don't know if my pointer works very well, right up in here, it is clearly within this tan area that's identified as an urban reserve, and this is a copy of the map that has been adopted by Metro. So the administrative rules clearly indicate what you do in a situation in the instance between adoption and acknowledgement of a comprehensive plan change or other land use change, and it very clearly directs you to apply the applicable criteria or policies that were adopted, and that once the change is adopted, the local government shall apply the change to land use decisions unless a stay is granted, which is not the case. So it's very clear that we do need to apply our comprehensive plan policies. Those policies are very specific and directive, and they prohibit the changing of a plan designation or zoning district designation of a property located within an urban reserve to allow for uses not allowed at the time of designation. Now, it's important to understand that that policy is also reflected in the 5-party IGA that you recently signed with Metro and the cities of Tualatin, Lake Oswego, and West Lynn. And that policy was put into our comprehensive plan because it is directed through the administrative rules, which is the administrative rule listed up there, 660-27-0070, subsection 2 actually specifically says that counties shall not change their plan designations or zoning district designations to allow for uses not allowed at the time of the designation of the urban reserve. It should be noted that farther along in that administrative rule in subsection 4, there are some exceptions in which you could make those changes to allow for new uses. They are very specific to 4 instances in which you could do that, none of which apply in this situation. They are things like public parks and certain transportation or infrastructure facilities and significant Goal 5 resources, and there's some land about various agricultural uses which don't apply here because this is not agricultural land. So it's very clear from the administrative rule all the way down through our comprehensive plan, through agreements that you've made with our partners in the region, that we just simply cannot change the zoning of this property. So really, in my mind, it boils down to 2 questions. Does the county need to apply its comprehensive plan policies after adoption but prior to acknowledgement? It's pretty clear in the state law that yes, we do. And are there any exceptions under state law that would enable the county to change the plan and zone designations of this property? And it's pretty clear through the administrative rule that no, there are not. So there's two other issues that bear some discussion. However, they become less relevant once you realize we are simply prohibited from changing the zoning designation of this property. If we were able to do it, it would still need to, the property would still need to meet the applicable criteria in our comprehensive plan and our zoning ordinance related to the zone change. And in our comprehensive plan, it is also very directive about what areas and what parcels we can apply a rural commercial designation to, and it very specifically directs you to areas that have an historic commitment to commercial uses. The applicant has argued that the area is the larger sort of Borland up to Wanker's Corner. There's some institutional church and school uses in the area. They've argued both that that area has a commitment to commercial use and that the subject property does as well. Staff finds that that's not the case. Staff asserts that the more appropriate area is the subject property because that's the only property that we would potentially be changing the zoning on. And it doesn't have an historical commitment to commercial uses. It has a variety of uses that have been on the property, but like I said, a home occupation doesn't commit a property to a commercial use at any given time, and I don't know the actual number, but there's hundreds of home occupations around the county that are happening on rural residential land, on ag land. It's simply an accessory use to a dwelling, and it's a temporary use, and it was only on the property for a few years. Temporary uses that ODOT had on the property, again, are temporary uses. And the nursery and landscape supply sales business is an allowed use under the RRFF 5. And so there doesn't appear to be any commitment to a commercial use, although there are some commercial uses on the property that are subject to a violation, which don't commit the property to a commercial use for the purposes of changing the zoning. So that's one issue. Again, if we were able to change the zoning of this property, that's something that we would need to consider. And then finally, the last issue is the applicant's traffic study. When you are changing the zoning of a property, you need to ensure that the proposal meets all of the applicable criteria in the transportation planning rule. Our comprehensive plan says that, and so does the transportation planning rule in the administrative rules. And what you need to do is compare the most traffic generative use under the current zone versus the proposed zone. And the applicant has proposed to use a baseline that both ODOT and staff find is not a reasonable expectation to use as a baseline, and it effectively significantly underestimates the size or extent of the effect that the zone change would have on the property. And ODOT has submitted 2 letters to that effect there in the exhibits in your packet. And I'm happy to answer more questions about that, but again, I don't want to belabor it because the main finding here is that the administrative rules, our comprehensive plan, prohibit us from actually from changing the zoning on this property. And so the remainder of the criteria that were listed up there relating to our zoning and development ordinance, section 1202, they are not met, but largely because of the issues that I just identified to you. The Urban Growth Management Functional Plan, interestingly, does not have any, has very few applicable regulations here, and those actually are met. However, statewide planning goals are not met because of the issues with the, I forgot to list goal 5 up there, but because of the issues with the transportation planning rule, and then of course the urban reserve area. So it is staff's recommendation that the Board of County Commissioners deny the 2 files for the comp plan and change and zone change for the following reasons: that it's located within the designated urban reserve. It also doesn't meet the county's historical commitment criteria, and the traffic study is insufficient to make necessary findings under the transportation planning rule. The Planning Commission held a public hearing on October 9th regarding this application. At that hearing, there was no agency or public testimony given. The Planning Commission, after a lot of discussion and questions, voted 5-1 to recommend approval of these two files. And the reasons that were articulated largely were along the lines that they support a commercial use on this property, that there are not necessarily any adverse effects on the area if the zone were to change. And while that may be true, that's unfortunately not the criteria that we need to meet. It's unfortunately not whether or not it's a good idea to put a commercial use on this property. It's whether or not it meets all of the criteria, and it clearly does not meet the criteria related to the urban reserve designation in our comp plan and under state law. And so that is the end of my presentation. I'm happy to answer questions if you have them.
Okay, are there any questions of staff? Seeing none, we'll move on to public testimony. We'll now open the public comment portion of the hearing. We'll first hear from the applicant, who will have 20 minutes. And are there any public officials here? I don't see any. And so we have 3 people who are the applicant, so you're gonna...
We're going to divide things up.
All right. And then representative CPOs or agencies, I don't see any of those either. And then after that, we'll have testimony from the public, and I have one of those cards. And then we'll close the public portion of the hearing and begin deliberation. So we have Rick Givens,
Yes, sir.
John Schockler, and Rob Fellow.
Good morning, Commissioners. My name is Rick Givens. I'm a planning consultant for the applicant. When I was a much younger man, fresh out of planning school with a master's degree from Portland State, I went to work as a consultant and soon found myself appointed to the County Planning Commission in 1979. And at that point, we were discussing where the urban growth boundary should be, and we were all looking at the Stafford Basin saying, gee, that looks like a pretty good spot, but for political reasons, it was excluded. That was about almost 40 years ago. And it has found itself in some sort of land use gridlock ever since that point, as the county has looked at Damascus and various other areas that you're all aware of. Mr. Fallow has owned this property for the past 20 years as Metro has gone through various planning processes trying to figure out when and if it will be urban or rural. But it's been basically in gridlock for a long, long time. What I'd like to talk to you about this morning is a couple of the findings that staff is saying that we have a problem with. First is the area, and if I could have that slide that I gave you. The county staff is taking a position based on a earlier board hearing where they determined that area meant the specific site in question. That I don't believe is a reasonable position to take in this situation. Area in land use parlance usually means the immediate vicinity of the subject property, not the subject property. The idea being that if you've got a piece of property that's sandwiched between 2 other commercial uses, obviously you're impacted in terms of being able to use your property for residential purposes or whatever by the fact you've got other commercial uses around you. On this slide, I've shown the entire area north of the Stafford interchange, along Stafford Road, the roundabout. The uses I've shown in blue are what in most land use parlance would be considered to be institutional uses. Athey Creek Middle School, Stafford Elementary School, Rolling Hills Church, the future fire station, Cambodian Buddhist temple, Metro's native plant center. All those things are uses that primarily serve the urban area. There certainly isn't enough rural population in the area to justify those uses. They're there because the land is available and because it's an area that has convenient access to the transportation system. Beyond that, the uses that are shown in red are commercial in nature. staff has argued that you don't count home occupations or other things that may be allowed by the RFF5 designation in some fashion. I don't know that that's true when you look at it in context of that particular plan policy, and that is whether the surrounding uses make it unreasonable to assume that this property would continue to be used for residential purposes. If you look at the site, it has a couple of different commercial uses on it, related to landscape services and rock. Across the street, you've got S&H logging and fuel. Further to the north, immediately at the interchange, you've got obviously Wonker's store, the saloon, little pitch and putt golf thing, and Par Lumber. Those are clearly designated rural commercial uses. And then there's a variety of other uses around the area that are fairly strongly commercial in nature. Classic signs down along the Borland Road to the east of the intersection next to the freeway. There's a contractor storage yard. There's the bamboo and koi gardens. There's Gigi dog care and kennel, RV storage. So there's just a lot of things going on at this intersection and virtually no residential use. This property is clearly impacted by the surrounding area in such a way that it's not reasonable to assume that it would be used for rural residential purposes. And that, I think, is the context of what the comprehensive plan policy is looking at. Secondly, the other point I'd like to make is that the issue regarding the transportation study. The applicant hired Kittleson and Associates, one of the most respected transportation firms in the Portland area, to look at this site in terms of meeting the requirements. ODOT has taken the position that using an outright permitted use, that is a government facility on the property, isn't reasonable because it's owned by private entities. Well, we just have seen up further north that Tualatin Valley Fire and Rescue is buying a site for a government facility. Properties change hands all the time. So we used what is clearly the most intensive allowed use in the rural residential zone. There's nothing that says that's unreasonable. And clearly, if we were to apply for a conditional use permit that could otherwise be permitted on this property, we wouldn't be saddled with the traffic generation of one home. We'd be looking at the kind of generation allowed by churches and schools and those types of things, which generate hundreds of trips per day. So we used what we thought was a reasonable comparison. And really what it comes down to is that wouldn't be a finding for denial. It just would be an argument over what the trip cap should be on the property so we didn't cause problems to the interchange. So that's something that can be worked out. Beyond that, I just would note that the Planning Commission looked at this area and they heard the argument staff is making. Mr. Schonkweiler will be talking shortly about why there are legal reasons why we believe the staff is incorrect in their position relative to the rule. But Planning Commission does what planning commissioners do. They look at what makes sense logically. This is a gentleman who's trying to make some reasonable use on his property to hold it until such time as it does become urban so that he can, and in that time frame, he's got to make a reasonable use to pay his taxes. And so we're trying to get out from underneath these enforcement orders and adopt a zone that would allow that to happen. There's no intent to convert this property, something that couldn't be redeveloped in the future. Frankly, the churches and schools have done that on other property that probably shouldn't have happened. So we're going to ask that you use some reasonableness in your decision this morning and look at this property as being committed to something other than rural residential. John?
On top is a copy of this map, so if you can't see the detail, you can pull one out for yourself. Right, I'll try to go through this quickly because we don't have a lot of time left, but the comprehensive plan, section 3, your comprehensive plan, when it designates zone districts that can be adopted for Clackamas County for rural commercial, says located in rural areas of the county to provide for retail, service, and office uses. It doesn't say use on a particular property, it uses the word plural. That provision of your comprehensive plan was adopted to be in compliance with what is marked as page 4 in this packet I gave you. That's LCDC's administrative rule for unincorporated communities in the rural community. And here's what it says. Rural community is an unincorporated community which consists primarily of residential dwellings, but also has at least 2 other land uses that provide commercial, industrial, public uses, including but not limited to schools, churches, grange halls, and post offices to that community. So since you adopted a comprehensive plan to be in compliance with that provision, you're allowed to look at this area. There's no question about that. Just trying to narrow this down to the land itself is an unnecessary restriction here. And the staff at the Planning Commission cited the Uten case. The problem with the Uten case is that was a rural industrial. It comes under an entirely different Oregon administrative rule with entirely different standards. It really doesn't apply here, and they're trying to slap that on top of it. Now, in your packet that I gave you, page 2 is a 2-page document. This relates to what is really 98% of this whole matter here, and that's OAR 660-027-0070, which I'll just refer to as 70 from now on. I don't want to go through all those numbers. First page is subsection 4, the exception section. The second page is the entire 70 section, so if you have any questions, you can flip back and forth. The important thing here is, because I'm a land use lawyer, have been for, frankly, almost 40 years now. As a lawyer in dealing with state statutes and administrative rules that are adopted to state statutes, which is the case here, the courts always look at what are the subjects in these subsections. And subsection 4 has 2 separate subjects, and the staff wants you to ignore that. But it has 2 separate subjects. The first subject is, do you need a Goal 3, 4, 11, or Goal 14 exception? If you don't, then that's the first part. The second part is, and that's the second subject, is if you do have to have a Goal 3, 4, 11, or 14 exception, then the second part applies. Now, what's the first part say? The first part says, notwithstanding the prohibitions in sections 2, 3 of these rules, the county may adopt or amend the comprehensive plan provisions or land use regulations as they apply to lands in urban reserves, rural reserves, or both. Comma. That's the end of that section. And then it says to separate the two, unless an exception to Goal 3, 4, 11, or 14 is required. And then, as I've summarized, you've got 4 categories below that are basically public-related uses that the county can apply. Now, the staff is basically saying, ignore that second part of the first section, because we don't want that to apply here, and that you think you've got broader authority than we want you to think you have. Why is the staff doing that? Because they've been following along with Metro for the last 7 years. And what's happened in 7 years? Nothing. We're back to right now nothing. It's on remand. Mind you, part of the remand, or part of the hearing before the Court of Appeals was, yes, they acknowledged, or they accepted a large portion of what Metro did, but there's a part of what Metro did got reversed and remanded back. So that's where we are with this. Basically, they're starting all over again. When was that remand back? That remand was back 2 years and 10 months ago. What has happened with that remand? Well, Metro's come out and entered into an intergovernmental agreement, you guys and the cities. The cities that, by the way, as was mentioned earlier, that's why you don't have an urban growth boundary down to 205 is because Lake Oswego, I was there back then when it was CRAG, down to 205 because those 2 cities, not for good planning reasons, just for self-interest, didn't want somebody building in their back door. And they're still pulling off that political gamesmanship, and Metro's still making political decisions, not region-wide planning decisions. So bear that in mind. I've already heard lots of land use attorneys point out that this IGA is basically a state-sanctified regional planning authority delegating some of its planning authority down to a couple of municipalities, which were the obstructionists all along, and there's a real question whether they can do that. So that's yet other issues for appeal that are arising, and that's exactly what President Hughes pointed out after the remand in the letter we submitted to the Planning Commission. He expects there's going to be more appeals, so we're not looking at 7 years of not getting a decision for these people in this land here. We're going to looking probably for another 4 to 7 years. So is there any real planning that's effectively going on? Back when this all started, Clackamas County Commissioner, or the Board of County Commissioners were basically told, go along with this, we'll solve all of this out here, and then you can go forward. Well, it hasn't happened, and it's not going to happen anytime soon. So now we come back to 0070, subsection 4 is a complete exception to subsection 2 and 3, which is where they say you can't make changes in the urban reserve and the rural reserve under 2 and 3. Subsection 4 is a complete exception to that. The question is, do we apply? Well, we have to look at the interpretation law for that OER. And I have page 10 of the documents I gave you as a supplemental, and I lay out the case law for this. Mind you, you've got the exhibits from the staff from various jurisdictions. Not one of them, if you go through those letters, those exhibits, not one of them tries to explain how subsection 4 applies. They just make a conclusion, oh, it doesn't apply here. They don't cite any case law. They don't cite any laws of interpretation, nothing. You've got it right here in this exhibit I gave you. So what does notwithstanding mean at the beginning of that? One person on the Planning Commission was worried about that. Well, here's what the cases say. The term notwithstanding overrules conflicting provisions of any other section of the law. So it overrules 2 and 3 if it applies. The Oregon Supreme Court has said the statutory exception exempts absolutely, that's the terms the Supreme Court says, from the operation of other provisions of the statute. So if it applies, it's like a house of cards for everything. The staff is talking about, oh, you've entered into an IGA, you've adopted certain provisions in your comprehensive plan that enforce the urban reserve. Well, they're all geared towards this OER. You even mention it, you refer to it. So if the exception applies, it's like a house of cards. You pull out the exception, all the cards fall down. You're not bound by it, even though you think, several people say that you, the staff says you are. You're not. All right, now, what is, we have the Oregon legislature has gotten fed up. Frankly, over the years I've been practicing law, I've watched that. They passed a state statute on interpretations. They're tired of people putting things into it that's not there and taking things out of it that they wrote in. They want all the language to have meaning. So in ORS 174.010, they state, or require, I should say, the reviewer, that would be you guys in this case, cannot insert what has been omitted or to omit what has been inserted. So you can't take the second part of subsection 4 where you limit things to 4 different uses and lift it up to the first part. Because the first part is about whether there's a goal 3, 4, 11, or 14 exception required for any use that you'd be using. That's a different subject up there. This is a different subject for the 4 down below. That's if the county still wants to go ahead and it is a goal exception requirement, then you can still do it under the 4. Now, the part that the staff doesn't mention here is if they were right about their interpretation, then why did LCDC even bother to have all that language in the first part? Because all they had to say was the county can approve these 4 items. It doesn't matter whether it's a goal goal violation, or I shouldn't say goal violation, goal exception or not under those 4 goals. They could have just simply said that. And we come back to the state legislature on rules of interpretation. You can't leave out what they wrote in. You have to give it meaning. And that's what the staff is doing. They're trying to leave it out. All right, so now, the other part of this is, it's a remedial statute. 2 and 3, subsection 2 and 3, prohibit uses completely. It's a complete prohibition. Subsection 4 is an exception to that, so it's providing a remedy. Here's what the courts have said about a remedial provision. They have long held that legislation and administrative rules of a remedial nature is entitled to a liberal construction, a generous construction, not a strict construction. And I've cited the cases for that. So now we come down to me, which is really the crux of the matter, that I've been practicing law so long here, I remember all the old statutes that were passed, and a lot of people who are so much younger than me, I think, have forgotten it, but we have a moratorium statute in the state of Oregon, and we've had it for a long time. And here's the problem. We have, still under interpretations, we have a series of cases, and I've cited them, that say that for legislation administrative rules, you are to consider in context with other provisions of the statutes and the entire statutory or legislative scheme. So when you look at this OER, you have to read it in conjunction with the moratorium statute, and you have to make them consistent with each other. You're supposed to find it so that it doesn't have a conflict. That's what all those cases state. They must be read together and harmonized if possible to give effect to both. So what does the moratorium statute say? Moratorium statute says before you can impose a prohibition, you have to adopt a moratorium first. That was never done here. Neither Metro, not LCDC, not you guys. Nobody adopted a moratorium. Well, maybe it's just a minor problem not doing that. Well, what's the rules? The rules are you can only adopt a moratorium for 120 days. You're allowed to have an extension of it for 6 months. So in other words, the maximum moratorium you can have in Oregon is 11 months. That's it. And this is 7 times longer than that, with the possibility of a lot longer than that. So, well, gee, is that really a problem? Well, I've cited some case law in here that it is a problem. The staff raised the point at the Planning Commission that, oh, gee, it's not a moratorium because people can still make uses of their property. I hope you'll give me a few more minutes to finish this, please.
I'll give you a couple more minutes.
All right, thank you. All right, so we've had a case on moratoriums here in Oregon. It's Home Builders Association versus City of Wilsonville. Here's what they said. They said, the statutory definition of moratoriums does not require a complete halt of the issuance of permits. Rather, a pattern of delaying in the issuance of permits is sufficient to constitute a moratorium under the statute. 7 years of delaying under subsection 2 and 3 is a moratorium. Is there a problem with that? Well, it went to federal court against the DEQ, and the federal court ruled that the delays by the DEQ in permitting, not permitting drain fields constituted a violation. It's an illegal moratorium, and the jury awarded $900,000 to the landowners, and the state of Oregon had to pay that. So this is a problem. This is not a minor thing. This is not just a little procedural deal you can overlook. So when you put it all together, the bottom line is you do have the authority to apply subsection 4. It supersedes, in essence, your comprehensive plan provision because it's based on subsection 2 and 3, and this is an exception to that. And the same thing with the IGA. You make references in there to the OER. Again, it's a house of cards. You pull that card out, and you have authority to make this decision. I have a lot of other stuff to talk about. If you have any questions, I'll be glad to go over them.
All right, any
Anybody have any
questions of
questions?
the applicant?
I have some questions for, well, just questions, but we can keep going and then ask at the end.
Mr. Chair, this is a very complex thing. I haven't even had a chance within that time frame to provide a little bit of testimony and some exhibits on significant issues to this.
Well, you had 20 minutes, and that time is up, and I extended it a little longer, so we have a time limit.
During our applicant.
You're really interrupting me. I'm looking to our lawyer. Yeah, go ahead.
We don't have any adopted standards. The time limit is imposed consistently throughout our land use applications. You do have the ability to vary that if you see fit, but 20 minutes is typically what we allow
Okay.
for our land use application, but it is up to the discretion of the commission whether to allow additional testimony.
All right, first let's go to your questions, and we'll talk about whether we want to add some time. Go ahead, you had some questions.
Let's make the decision if we're going to have more testimony, and then
Okay.
I'll save my questions, because they might get answered with more information.
All right, do you guys want to allow more time, and how much time?
I could go with another 5 minutes without a problem.
Okay, you good with that?
Yeah, let's do it.
All right,
Yeah.
we'll give you 5 minutes.
Go ahead.
Yeah, okay.
Why don't you give,
Thank you very much.
give them a copy of your documents?
I've got some exhibits, documents here relating primarily to the history of the property, and the staff has brought up some issues with violations. And real quickly, in the history, whether it's in a rural residential home occupation, if it's a commercial use, it's a commercial use. And the commercial use there was from 1985 on, was an electric contractor. It was not a small business. He rebuilt the pole barn to include 40% offices in it. ODOT used those offices, he used those offices. It was a fairly good-sized business. That's immaterial, really, because the county can only go back, according to ORS 215130, for up to a max of 20 years to look at historical use. Going to the original 1997 conditional use application, that came up in a pre-app that the staff was concerned when we looked at wanting to put in an operation there. They were concerned about selling rock. So they suggested we do a conditional use. We put in for a conditional use. The hearing was about the rock primarily, but the underlying uses were nursery, but also landscaping services. If you would look under, Exhibits 1 and 2 have to do with the use prior to 97. But if you look at Exhibit 3, the staff report even outlines on there that the facility was going to be part of a nursery-landscaping function. There's always going to be a landscaping. The staff knew it. The hearings officer knew it. Both those pieces indicate that. Under the 10-year policy, we weren't aware of a 10-year policy. We went through that hearing and we thought we had a allowed use. It wasn't until in 2008 we got a violation statement. We went through a complete arduous process. If you look at Exhibit 4, we put in a complete 10-year history for Dean Brown, who was a county compliance code specialist. And he felt that we definitely followed what he said at that time was a 10-year criteria. Whether or not they were even going to look at a violation or not, he closed the file on it. He said, this is, I don't see a problem here. And if you look at that letter, you look at all the criteria he asked us to do to show continued use, he was satisfied. That's part of the history that the county has had. In 2011, I got a letter from a staff member, said that we were in violation. She closed that file a month later after we talked about it, when it applied to the 10-year violation code, 10-year policy. She didn't mention anything at that time that in 2009, supposedly the county, as they say, had eliminated that 10-year policy. But she closed it in 11. In 14, I got a letter that said, you have a violation, same violation. And I asked what was going on about it. Didn't get any information back. And in 12, 14 of 15, over 14 months later, I get another similar notice. And then finally, I asked for more information, sent an email. Finally, in January, I got a letter that said, oh, by the way, the 10-year policy has been eliminated. I said, well, why did you okay it? It was the same person. Says, oh, it was in 11. In 12, she said, we really closed it. So in 14, she said 12. So I've got different information from staff. I'll give you this testimony in a little bit. But we had in 16, we met with staff. We had a tenant that tries to make a change in it, putting a nursery in. We didn't have the nursery continuing to go after 5 because our well dropped capacity in half. We went from 110 feet static water level down to about 217 feet. So we had to eliminate the high usage of water with the nursery. Went over that again with the staff. We are now in the middle of a violation hearing that the staff has told us that
Need to finish up.
okay, that we were not able to get a new 10-year policy. We're not able to get a conditional use permit. The only thing would have to be a zone change. That's what they told your planning commission, and that's what we are doing right now, is trying to resolve it with a zone change to keep our people going there. Thank you very much.
Thank you. So with that, we have 2 citizens. Anthony, I'm going to guess this is Regis. Is that your name? So Anthony, go ahead and come on up. And Regis, you're up first. You have 3 minutes. Oh, tell us who you are and where you live.
Good morning. My name is Regis Rojal. I moved into the Westland, Stafford, Rosemont area in 1936. Been around in that area for 80 years. I've seen many things slowly happen. Pertaining to Rob Fallow's been a friend for 40 years. I've seen him active with good vision in the Stafford area. He's offered really good ideas and has worked very hard for the public. I really feel that you should have good judgment, just common sense, and vote in favor of what Rob Fallow's vision is. He really does have good vision and good thoughts and a good person. Thank you.
Thank you.
I'm Tony Angel, and I lease the south side of the property from Rob Fallow. I'm the guy with the landscape and the pigs and the chickens and all that. We do Christmas trees and such things. It'd be nice to, I guess, be able to expand the business into maybe an antique store and such, which I don't think right now we can underneath with the current zoning. I've been renting from Rob for about 15 years. He's been an excellent landlord. He's always been very helpful, and he's very cautious about what we can do down there as far as with the current zoning. And so it'd be kind of nice to have a different, have more room to grow the business, not have to worry about some sort of county crackdown all the dang time. So that's about it.
All right. Thank you. Well, with that, I have no other cards. We will close the public portion of this hearing. And we'll discuss and deliberate on and consider this application. So what do we want to do? Want to talk? Somebody want to talk?
Well, I have a question.
Oh, yeah, you had a question. Staff.
Yeah, so it's probably a Nate question. So Nate, I'm reading the OAR, and I'm just interested in knowing, so if you look at section 4, and it says unless an exception to goal 3, 4, 11, or 14 is required, can you describe to me what the process is to get one of those exceptions?
To get a goal exception? Well, Martha can probably set me straight here, but generally it's, it's an analysis, right, where your goal 3 is agriculture, goal 4 is forest, of course, and I use those as an example because those are typically the goals that you do find more often than not are being taken an exception from. Those are policies that are promulgated by the state, which say generally this area is suitable for that resource use. Oftentimes we'll see commercial or industrial uses, for instance, want to convert that designated resource land into a commercial or industrial use. And what you then do, or what you see then, is an analysis of other goals that may have priorities over the agricultural or other resource zone. And so sometimes it is a matter of looking at other goals and finding which one should take precedence over that particular goal. Sometimes the conditions on the ground justify the conversion out of agricultural other resource use. So for instance, there are what's known as an irrevocably committed, an exception where the ground is in such a condition that it really isn't suitable for any more resource use. Sometimes that would justify a goal exception. There's a committed exception, if I'm not mistaken there, where the surrounding areas are so committed to property that really, or to those other uses, that it makes no sense to continue agricultural use on that particular property, or there's other reasons that justify. So there's a number of avenues to take exceptions from that. It's hard to encapsulate because they are complicated applications.
Right.
Yes.
Well, my question is more about the procedure. What is the procedure to, I mean, you do the analysis, and then what is the process to get a goal exception?
The process here at the county is a couple different hearings, I guess. It's what we call a type 3. Or type 4, yeah, it's type 4. I'll turn it over to Martha, because she can get more particular
It's
about that.
essentially a comprehensive plan amendment. You recently heard a goal exception application for a large solar facility. That was an exception to Goal 3. And so the process was to go, similar to this, to public hearing to the Planning Commission and to the board, and amend the comprehensive plan to identify that goal exception.
And there are certain, when you ask for a goal exception, there are certain criteria that is
Yes.
met. Could you describe at what point the criteria requires a goal exception?
I don't know if it would be the criteria that would require a goal exception. It's the application, the nature of what's being requested that would drive whether a goal exception is necessary or not. So again, for instance, if it's resource use and the ask from the applicant is to convert it to something other than resource use, that's what would trigger the goal exception on the criteria that go along with that.
Because what I'm just trying to wrap my brain around, because I've spent much time with this part of the OAR and trying to wrap my brain around, we can't do certain things under Section 2. The county shall not amend a comprehensive plan provision. But we can do it if there are these certain uses. And so what I'm trying to wrap around my brain, I'm assuming that there are certain things that we can do that require us to go for a goal exception, and then there are certain situations where we just simply have the authority, which is outlined under A, B, C, and D. But I'm just trying to separate those in my mind, because the way that I read this statute with the commas, the way that they are, unless an exception to goals 3, 4, 11, or 14 is required. So there is something that triggers a requirement for a goal exception that you have to go through a different process than us just sitting here and saying, okay, well, we can make an exception for goal 5, we can do it for parks, we can do it for roads, we can do it. So that's what I'm trying to figure out, is what triggers that exception? What is the criteria? What is the process? What triggers that?
I can give you an example. It's not the same across the board for the trigger, but an easy example to wrap your head around are transportation uses. And so under this exception in an urban, I believe it's in an urban or rural reserve, you can approve certain transportation uses as long as they don't require a goal exception. There are certain transportation uses that don't. Things like simply widening the road and existing right-of-way. I don't know the whole list of them, but there is a list in the statute. Then there are certain transportation uses that require a Goal 3 exception. A brand-new road through agricultural land would require a goal exception. And so what this number 4 is getting at is that in an urban reserve, you could allow some new uses relating to these certain things, parks or transportation, as long as they don't require that goal exception. And so there is a threshold for each of these various uses that you're allowed to do without the goal exception, and then once you exceed that threshold, you are required to get the goal exception.
Yeah, and that's what I'm just trying to understand, is like, what is that threshold? What is that trigger
Well, it's going to
point? What is
vary
that
by
criteria?
use.
Because I'm just wanting to really understand what our authority as the Board of County Commissioners is. but how I'm understanding it is that unless an exception is required, we can just do these A, B, C, and D.
Yes.
Okay, Ken, question?
I did not find in the literature, and if I understood correctly, there are some violations of current zoning uses on the property, is that correct?
Yes.
Can you share what those alleged violations are?
Well, the information in our permit system state 2 businesses on the property, but I believe that one of them is the business that's allowed, the landscape supply sales, and then it identifies a landscape contracting and maintenance business, which is not something that's allowed in the rural residential zone. So in other words, you can grow product, you can sell, grow nursery stock, sell nursery stock and some associated landscape supply, but you cannot run a commercial business to be a commercial landscaper and maintenance and going out to various properties.
And it was implied that there's some sort of a moratorium on development in the area. Now, I understand that there are several uses that are currently allowed in that region, such as building a house. Are we, or have we prevented anybody from building a house?
No.
Not if it's allowed.
So there's no moratorium on the current allowed uses, am I not correct?
There's no moratorium on developing your property under your current zoning designation and all the allowed uses.
Thank you.
So I live in an RRFF5 area, and not far from me is a Fred Meyer's, a Wilco. I think the argument that that we should allow this because the other uses nearby are commercial frightens me, frankly. I mean, if my neighborhood would blow up if that was true. I mean, all land use decisions are made on a particular property. Rob's a friend too. And he has, and like somebody said, I think he has some great ideas. And frankly, this should be allowed, but it's not by state law. My relatives, the Lanfears, are suing over the urban rural reserves. I would have to make the same decision on my cousins, what I was going to do. But, we worked really hard with the community to come to an agreement. And I've been here since the day we started this in 2010. I helped Charlotte look at the urban rural reserves. I went through all of this. But, it's, and I've also had some experience with historic uses. Milwaukee, our business was there for 92 years. And I had to argue whether the historic use in a particular building on my property was appropriate. And I was the mayor and I lost. They said I had to put a barber shop in there, or I had to add housing, and it was of my own making. But we adopted a comprehensive plan in 2010. We did that based on the urban rural reserves that were discussed, and we've worked hard to try and accommodate the needs of both the village and the cities that surround them. And in our agreement, there was an effort by the villages to change the zoning. They wanted to allow some people who had smaller sites do something, partialize some of their properties. And we couldn't do that based on the law, which is we have a comprehensive plan and we're in the urban reserves and you can't do that. It's pretty straightforward to me. One other thing. I think we argue about words. May means something different than shall. But in this case, shall is quite obvious in the law, and it doesn't give us the options that we might like to have. And it says exceptions do not apply. That pretty much answers the question to me. So let's move on to Martha, and then Ken, you want to add more?
Yeah.
Okay.
Do you want Ken first, or no?
go ahead.
Okay, so I just wanted to ask about 4D. Uses in land divisions that are allowed by state statute or administrative rule at the time of the designation of urban and rural reserves. I'm trying to wrap my head around, why wouldn't that apply in this case? Or would that apply? It seemed to me one of the assertions of the applicant was that would that allow us to change it? That one provision? There's a gap here. and I'm
4D that
trying
says
to-
other uses in land divisions that a county could have applied under ORS 215.130. Are you talking about that provision?
I'm talking about 4D on page 3.
Uh-huh.
Yeah.
Oh, did he not
Is that the
state
material they handed us?
Uses in land divisions.
That's the material
They handed us, okay.
the applicant handed us.
Yeah, but
Okay.
it's actually right from, it's actually right from the OAR, right? From 660.
On page 3, no. The OAR,
Okay.
which is on the next, where's the whole thing? No, that's not the entirety
Backside
of
of
it.
that page 4.
So if you go to Exhibit 11 in your packet,
Okay,
4D, the entirety of 4D reads, other uses and land divisions that a county could have allowed under ORS 215.130, sub 5 through 11, or as an outright permitted use, or as a conditional use, and it goes on to list several other statutes. If the county had amended its comprehensive plan to conform to the applicable statute or administrative rule prior to designation of the rural reserve. What that is referring to is if, under state law, there are uses that are allowed in agricultural land.
right.
We are not required to allow all of those on a county level, but we can, and there are some counties that are more restrictive than state law. Our county is not, to my knowledge. And it's saying that if it was allowed under state law at the time, even if your county comprehensive plan didn't allow it, you could change your comprehensive plan to allow those things. And the other reference in there is to non-conforming uses, which are uses that were legally established and have continually existed prior to the initial zoning, or the most restrictive zoning on the property. So neither of those apply here because this is not agricultural land and we're not dealing with a non-conforming use that existed.
Okay, that clarifies, because that was the one thing I thought, I'm not quite getting it. Thank you for that.
Okay, Ken?
Thank you, Mr. Chairman. I had my questions answered, so I just had some comments before we go forward. Certainly, the applicant's considered use of the property is potentially appropriate in the future. That's understandable, given the location. However, the law seems pretty clear to me. Even though I'm not an attorney, we've had a number of attorneys review this, not just ours, but others, and that suggests to me that the legal requirements are pretty clear. The intent of the legislature also seems clear in terms of how we are to deal with rural reserves, or excuse me, urban reserves as we go forward. I always have a problem when someone asks for an exception to the rules when they're not currently following the rules. And that appears to be the case in this circumstance. That does not lend itself to confidence in what they will do in the future. But the most important issue to me is that we took the lead with Metro, three other cities, and the community to try and resolve the Stafford remand. And it took a lot of hard work and a lot of time to finally get to an agreement that worked for the majority of the communities that are involved in this. And I would feel that we are derelict in our commitment that we were very public about in supporting both the community's vision as was presented to us, as well as the concerns that the surrounding cities have. The intent of the agreement was to have the cities working with that community to develop a comprehensive plan as and when development goes forward and is apropos to the area. I think we have an obligation, both under the law as well as a moral obligation, to live up to that agreement, and so I do not find myself able to support the applicant in this situation. Thank you, Mr. Chairman.
One thing about land use is that it's best that you be specific. So my recommendation is that reference be made to the criteria that the county staff suggested, or if you want to vote in favor of it, reference your own material, I guess. Okay?
Yeah, I just-
Yes, Sonia.
Yeah, just some comments. I get frustrated when government and processes and planning doesn't work for what seems practical. And it is frustrating because we know, I've driven all through the Stafford area. I've seen the areas, there's consensus in the community of certain areas that should be developed in the future. We just went through a planning process. We understand what the steps will be to have consensus around how those changes will occur. What I am reading here is, and it's very legalistic and it's very much my lawyer's interpretation. So if we're wrong, if I'm wrong and you appeal, I mean, that's the right here to do that. But how I read this is that we shall not make changes. We shall not amend unless there are certain things that we can do which deal with agricultural, forest, facilities, and urbanization. If those uses rise to a level of a kind of goal exception, we have to go through that process. But this use isn't allowed for us to have the discretion. I mean, I wish we did have the discretion. That would make a lot more sense. I think after we go through the planning for each of the, through the cities and through what we have laid out in the intergovernmental agreement with input from the Stafford Hamlet, that this will absolutely be part of that future process. But I do not see, as the Board of County Commissioners, in looking at this from the land use hearing today, that we have the authority to do what's being asked. And that is the reason why I don't see any other choice but to vote in denial of this.
Martha.
Okay, I just want to just mention the Planning Commission. I understand they voted in favor of it, but it really wasn't as much of a technical vote, which I think we're bound by, as it was, it makes sense.
Practical.
And it does make pragmatic sense to do it. And so I can't go forward and support it either, as much as it pragmatically makes sense to do so. But it seems pretty clear to me, having worked on land use since before 1997, way too long. So I just want to know, in terms of, in order to get it developed, it would have to be annexed into a city at this point? Or no, it has to be brought into the urban growth boundary of a municipality, and then that first step, and then that triggers zoning, the planning process. So, and my understanding is the closest city is Tualatin to do that, Lake Oswego.
I think it's assumed that Tualatin would
It's
eventually
assumed, yeah.
take this particular area in the Stafford Urban Reserve.
Yeah, so that's really the process that will trigger the changes that logically should happen there. And as I said, then there's the IGA, which I agree with Ken, that we signed in good faith. And so to go against that at this point would, I think, question our legitimacy and credibility with the partners. So, yeah, I don't, as much as I would like to go forward with this because it makes pragmatic sense, I feel like our hands are tied with it.
So in this case, if you wish to deny it, I suggest that you deny and read this little bit of line here, and reference the staff recommendation. That's all. I mean, you don't have to do that, I think, but I think it's cleaner. So, let's see, are we done with deliberation? So, I'll entertain a motion.
As per the staff recommendation, Mr. Chairman, I move to deny Z 0373-17-CP and Z 0374-17-Z.
Is there a second?
I'll second.
Been moved and seconded to deny Z 0373-17-CP and Z 0374-17-Z as recommended by staff. Any further discussion? All those in favor say aye.
Aye.
Aye. Opposed? Hearing none, motion carries unanimously. Okay, let's see. Gotta read the stuff. Okay. Now that the amendments have been approved, I will direct staff to draft an ordinance reflecting today's decision included on an agenda for board adoption at a future business meeting.
That's if it's approved.
That was if it's approved.
Chair, what
Yeah.
we'll do in this circumstance is bring back findings for you to adopt at a later business meeting. And so
That sort of says that, but,
sort of says that, but we won't be bringing an amendment
okay.
before you.
All right. And so with that, we'll close hearing on Z 0373-17CP and Z 0374-17Z and adjourn the meeting. Okay.